There are three forms to dismiss an employee: misconduct, incapacity, and retrenchment. In today's video, we're going to be talking about retrenchment. My name is Aslam Mullah and I am a registered attorney. Today, we're going to be looking at how to follow a retrenchment process from a legal perspective to make sure that you don't lose a case at the CCMA or Labour Court. Retrenchment is seen as a no-fault dismissal. In other words, it is done because the company needs to retrench employees. It's not because the employee has committed some kind of misconduct. As I've indicated earlier, it can be done legally in South Africa. However, the proper process must be followed. The question then is, what is the process for a lawful retrenchment in South Africa? The most important part of the process is to consult with employees, which means that you must give them a document called a Section 189 notice. Usually, a Section 189 notice must be provided. A 189 notice is generally available for free online via an internet search. However, if you want a copy of it, you're welcome to also contact our offices regarding this notice. Make sure that you have valid reasons for the retrenchment. Now, there's three types of reasons that you can go with. Number one, structural retrenchment. Number two, technological retrenchment. And number three, financial retrenchment. In other words, you have to select one of those three grounds as a means to dismiss the employee for retrenchment. The next important point is to make sure that you have fair selection criteria for dismissing an employee. In other words, you must be able to select and justify why certain employees are going to be dismissed for retrenchment. The most common selection criteria is lawful, last in, first out. In other words, the last employees that have joined, those employees will be retrenched. In other words, it is a fair and objective selection criteria. What you don't want to be doing is firing people you don't like or people you don't get along with. The next important point is to give the employees an opportunity to make representations. In other words, allow them an opportunity to speak and come up with proposals to avoid being retrenched. You must then genuinely consider these alternatives to retrenchment. Don't just brush them off, genuinely apply your mind to it. The key is to try and avoid dismissals where possible. In other words, can you give pay cuts to the employees? Can you structure it on working less hours for less pay? If dismissal is the only option on the table, then there are certain other requirements that need to be complied with. For example, severance pay needs to be paid to the employees. Severance pay is a mandatory amount of money that needs to be paid to employees by virtue of the retrenchment. This is in terms of the Labor Relations Act. It's non-negotiable. How do you calculate severance pay? Well, the minimum requirement is 1 week for every completed year of service. The next important aspect is to pay the employee the outstanding leave and any notice pay as well. Also make sure that you give the employee important UIF documents like the UI-19 form. In summary, retrenchment can be done. However, the process must be fair and the lawful procedure must be followed. If it is not followed, you run the risk of losing a case at the CCMA or at the Labour Court. If you need help in your situation, whether you are an employer or an employee, you're welcome to click on the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.